state your name for the record.
Joe, I think you're muted.
I'm sorry, Joe Mastrogiovanni for Jamex.
Okay, let's go ahead. All right, are we ready to proceed?
Yes, Your Honor. So, Your Honor, this is Tim Durst, and we have before you a motion to strike. And the motion to strike, Your Honor, is a request that the court deal with improper filings made by Jamex in this case in violation of the court's order or protective order in the prior proceeding between Jamex and Whiting, the court's protective order there. With the court's permission, I would love to be able to share the screen to walk through some issues related to the motion to strike, as well as in response to the court's request of us last week that we provide some additional authority related to the court's discretion in this area. Is that permissible, Your Honor? May I share my screen?
And I think I just enabled that.
All right. And let's see, are you getting it yet? Not yet.
Yeah, I see it.
You got it? Okay. So let me get it to a more usable view here. Your Honor, this is a slide. What we have in front of you is a slide that you've seen before. This is an excerpt from the Jamex-Whiting protective order that Your Honor entered in September of 2018. I do note that it was agreed at the time that it was entered. Jamex counsel agreed to this along with Whiting counsel. And it plainly says that information that is used in that prior case and labeled confidential information, highly confidential information, including information produced by third parties, and so that would be including information produced by Stusco. It's to be used solely for that case, and any other use, including other litigation use, is prohibited. Your Honor, we called this order to Jamex's attention before they made the current filing, and they proceeded with the filing nevertheless. Your Honor, there were 5 potential filings or attempted filings by Jamex that were made that were issued in this case or issued in this motion. And they were all labeled with language that said filed under seal pursuant to protective order. Of course, there is no protective order in the Stusco case. It was submitted to the clerk that way. Apparently, I'm told that 2 different persons in the clerk's office, Your Honor, received different pieces of those 5 filings. 3 of the 5 filings, Your Honor, were rejected by the clerk. 2 on account of not having, of claiming rights under a protective order that did not exist. And those 2 filings were rejected outright. 3rd filing, as I understand, Your Honor, was rejected because Jamex had put it together improperly, formatted it improperly. So 3 of the Jamex 5 attempted filings in violation of this protective order, Your Honor, were rejected outright by the clerk's office. 2 of those filings, so I believe, I'm understanding that those 2 were dealt with by a different human in the clerk's office, so 2 different people addressed them. The other 2, Your Honor, that clerk also noticed that Jamex was claiming rights to a protective order that did not exist or did not apply to this case. And so that clerk also took action, but chose a different route and accepted the materials for filing, but did not file them under seal. So Jamex attempted 5 filings, 3 were rejected by the clerk, 2 were accepted, but the clerk noticed that there was an attempt to invoke an inapplicable protective order and did not file those under seal. Those 2, Your Honor, those 2 filings that were accepted were the subject matter of the telephone hearing that we had with Your Honor last week, and you entered a temporary sealing order last week. So there's no real dispute here, Your Honor, about a violation of this protective order. The briefing back and forth that the court may have noticed, there was some discussion about how much of the material that was filed was subject to the protective order, or whether it really did Stusco any harm, some issues like that. But there really is no dispute that Jamex filed materials in violation of this court's order. And there's no dispute that it wasn't accidental. I mean, we told them about it in advance. Happily, the clerk sniffed this problem out and dealt with it properly in 3 of the attempted 5 filings, but we now need to deal with the other 2. So, Your Honor, the court has a number of different avenues to deal with this circumstance. And I'm going to tick through a couple of them that I think may make the most sense for this particular instance. Here's the first suggestion, Your Honor, and this is that you simply supplement the order that you already entered last week. On May 4, you entered a sealing order. The court has the authority to make, of course, docket entries. And our suggestion under this scenario, Your Honor, is that you enter some docket entry filed in violation of court order or filed in error or something of the sort. And simply instruct that Jamex not pursue the current filings. And let me be clear, Your Honor, we're not arguing that there's some permanent prejudice to their motion for summary judgment, or that they should never be allowed to use these materials again, or that these arguments should be rejected with prejudice by the court. We simply need to get this filing cleaned up and proceed in the ordinary course of business. The court will recall that not only do we have the violation of the court order at issue here, we also have this unfairness issue of these materials were developed on a discovery record with Whiting involved, but without Stusco involved. So many of the materials that were filed in this filing, Your Honor, were the first time we had seen them. But the court can make a docket entry and simply order that this filing not be pursued, and then the matter would to our view, the matter would be resolved satisfactorily. We did discuss this with Jamex in advance. Ms. Shigeris and I discussed this. She entertained the notion, but ultimately Jamex, I think after she spoke with Mr. Reese, Jamex decided not to accept it. So this is option number 1, Your Honor. You can simply supplement the order that you have on file by making these entries. Here's another option, Your Honor. The court can reject a filing. Now, let me start with what I know is the court's instinct, and honorably so, and that is that Rule 76 and the open courts provision in Texas require that court proceedings proceed in the open, and that nothing should be sealed without following proper procedures. Your Honor, the purpose of Rule 76 is so that the public knows what is going on in court proceedings. It's not meant to be, and it doesn't purport to be, a requirement that things that are filed in error can never be unfiled or can never be addressed. Rather, the intent of Rule 76 is simply to avoid circumstances where the court proceeds without the sunlight of the public being able to see what's going on, and hence the court's broadcasting today on YouTube. So there are ways to deal, Your Honor, outside of Rule 76A, or separate and apart from Rule 76A, with filings that are made improper. And this slide that we have in front of you demonstrates some of those. The clerk has authority under Rule 21F. They can reject improper filings. In fact, Your Honor, that's already been partially implemented here. So remember, there were 5 attempted filings, 3 have already been rejected. The clerk can simply reject the other 2, and the clerk has that authority under Rule 21F. And that authority has recently been embraced and acknowledged by the Dallas Court of Appeals, as we note here in the Barr case. Similarly, Your Honor, there was a relatively new Supreme Court order. It was issued in January of 2020. It's on miscellaneous docket 29012, and it relates to electronic filings. And these filings were attempted to be made by Jamex electronically. Under the broad sweeping provisions of that order, the clerk can, on its own initiative, reject e-filings. And again, in this instance, your good clerks in the Dallas County Clerk's Office did the right thing and rejected 3 of the 5 filings. One of the ways in which one of the branches of authority the clerk has to reject filings, Judge Hoffman, is upon your request. This order from the Supreme Court specifically says that the clerk can reject a filing upon the judge's request. So this Supreme Court order supplements the authority of the clerk by giving the court, you, the authority to request the clerk to reject a filing. Of course, there are also local rules, and Local Rule 2.04 gives the clerk authority to reject non-conforming filings. So this, Your Honor, would be another approach.
Mr. Durst, you keep dipping your voice. Can you speak up for me a little bit?
I certainly can. I'm sorry, Mr. Reader. So, Your Honor, these rules, Rule 21F, the Supreme Court order, and the local rule all give authority for these filings to be rejected, Your Honor. And this would be a second option for the court to pursue with respect to our motion to strike. And that would be a simple order to the clerk saying these filings should not have been filed in this case. They were in violation of court order, and the filing should be rejected. And the clerk can do that either on its own initiative or under the Supreme Court order, Your Honor. The clerk can do that upon your request. So that's the second option. The first option would be to supplement the sealing order. The second option would be to reject the filing outright according to the authority that we've laid out here in this slide. Another option exists, Your Honor. This is the third one, and this will be the last one I present. Your Honor, the court has authority to simply deny the motion or to strike the motion. And it's given that the court has already sealed the motion, this is sort of an analog to simply supplementing the court's order from May 4th. You have the broad discretion and authority to strike pleadings. You could strike this individual filing or simply deny it without prejudice. And again, Your Honor, we're not seeking to gain some substantive advantage by this. But at the end of the day, Your Honor, all of these things add up to this. There was a violation of Your Honor's order. It was a knowing violation of Your Honor's order, and there should be a remedy for that knowing violation of the court's order. Any of these three options, supplementing your sealing motion, rejecting the filing, or denying or striking the motion altogether, Your Honor, would be an appropriate remedy we submit for Jamex's violation of the court's order. And that's what we request, Your Honor.
All right, response?
Thank you, Your Honor. Mr. Durst, do you mind taking your screen off?
I sure will. Hold on. There we go.
Great, thank you. I want to take a step back and address a couple of things that were in Shell's late filing on Friday, and then walk you through what we believe to be the proper action in this case. So Shell made a point over and over again, Your Honor, in their motion that the reason the court needs to do something in this case, strike the pleading, put some kind of notation on the docket, is because Jamex and its counsel falsely represented to the court and the clerk that there was a protective order in this case. And because I take that allegation very seriously about whether or not we made a false allegation to the court, I want to correct that. In the motion for summary judgment that was filed, there was a notation on the cover sheet that said the filing was being made pursuant to protective order. The documents, as we've talked about, Your Honor, are governed by a protective order in the related case, the Whiting action, and that's why we noted it. When I spoke with Rosemary in the clerk's office before she rejected some of the related filings, our motion for leave to extend beyond the 25-page limit, I specifically explained to her that we filed it pursuant to a protective order in the related case, that the court had not entered a protective order in this case, and thus she rejected that. But before any of that happened, Your Honor, on the same day we filed the motion for summary judgment with the notation that it should be filed under seal, you'll recall that Jamex's counsel requested a status conference with Your Honor to address this very issue. How do we proceed with discovery and motion practice in this case, given that discovery has happened in another case and there's a protective order that governs it? At that status conference that happened the following Monday, and to be clear, when we filed the motion for summary judgment and asked for a status conference, we never set the motion for summary judgment for hearing, and we have never set it for hearing since then. At that hearing, Your Honor, you'll recall, we explained this issue that's a little procedurally unique. That is, we have a related case that stayed because of a bankruptcy. We cannot go into that case and say, Your Honor, we'd like to move to amend the protective order to allow us to use some of this discovery in this related case, We can't go in. We were about to file a motion to de-designate what we believe were over designation of documents and deposition testimony by Shell. We had just conferred with them on that. And then Whiting filed for bankruptcy. So we had not had an opportunity to do that. We can't do that in this case. So we asked Your Honor, how should we proceed? You said, let's not set the motion for summary judgment until we can figure out these protective order issues. We followed that. Then we discussed, let's try to reach an agreement between Jamex and Shell as to what to do with the Shell depositions from the Whiting action in this case. We've attempted to reach that agreement, and we're in agreement other than one small difference that we'll ask Your Honor to rule on today on a separate motion. And then we told Your Honor, we will not use the Whiting documents from the Whiting action. We will subpoena Whiting in this case, and we will get them to reproduce those documents in this case so they can be governed by a protective order in this case. We told Your Honor we would do that, and we have since done that. So we are not setting the motion for summary judgment for hearing. The reason we could not reach an agreement with Mr. Durst on this issue was because he wanted to include as part of the agreement this, what I would say, punitive language from the court saying we filed this in violation of a protective order, or some agreement that we would never file this summary judgment for hearing, but we could file something similar down the road. And you could see from our perspective concerns about, are we then going to have a fight down the road? Is this similar or the same? And because the summary judgment issues in this case, we expect to, I think both sides expect to file summary judgments in this case. That was too big of a risk. So what is the real issue that we're facing? They want some kind of punitive action by this court for whatever reason. We think it's really, from a practical perspective, handled. The filing has been sealed pursuant to the order that you entered in this case. That's based on the protective order from the Whiting case. We're pursuing discovery in this case, so that way we can then file a motion for summary judgment based on the discovery in this case. And we don't intend to file that motion for summary judgment for hearing, set that for hearing at this time. So we think that handles it, but I'll just briefly address the 3 points that Mr. Durst raised as to the authority that you asked for, Your Honor. From the beginning, what I've told Mr. Durst is, I'm concerned about asking the court to remove something from the docket because I'm not aware of any express authority that the court has to do that. And as Mr. Durst alluded to, and we mentioned on the hearing last Monday, Rule 76A says the court may not remove any court records unless it's pursuant to a statute or a rule. It does not even allow the court to do it pursuant to an order. I asked Mr. Durst on multiple occasions, give me some authority that you think the court can remove this from the docket, and we'll consider that. We never heard from them until Friday afternoon when they filed this brief. The first thing is, like I said, Your Honor, I think their request to have a notation on the docket that this was filed pursuant to a protective order is really just some request for a punitive action against Jamex, but really doesn't do anything that's not already done. It's sealed, and we're not filing it for hearing, or not setting it for hearing at this time. But the second point they raise is, well, you can reject it under Rule 21F. The problem with that, Your Honor, is both Rule 21F and the cases that Shell cites in his brief relate to before a clerk has accepted it. When you file something electronically, as you know, Your Honor, the clerk then gets the envelope, can either reject it at that time and then note in the rejection the reasons for the rejection and a time for you to refile it, or they can accept it. That neither that rule or the cases deal with the situation once the clerk has already accepted it and it's already entered on the docket and part of the court record. And the third thing is that they pointed to is your court's inherent authority to strike pleadings. Well, the cases that they cite, Your Honor, and it won't be a surprise to you, of course, deal with a case where you're striking someone's defenses or you're striking a cause of action. They're not, none of them talk about a situation where the court actually removes something off of the docket. And that's the concern we have with what Shell is asking you to do, Your Honor.
I mean, this seems kind of like a tempest in a teapot at this point. I mean, what are we really fighting over? Whether or not I make a docket entry or something saying that this was filed in error? I mean, why are we really even fighting over this? This is sealed. I guess the real question is if this ever gets, what are you planning, Ms. Shigaris, kind of going forward? Are you planning to do a new summary judgment with appropriate attachments and setting that for hearing?
Yes, Your Honor, that's our intent, is that it would probably be identical to the summary judgment on file, other than instead of the exhibits that were attached that have Bates numbers from the Whiting action, they would be Bates numbers under this action. And the testimony.
Doesn't that assume that all of the documents from the Whiting action will move over to the Shell action?
Well, it does, because we've now subpoenaed those Whiting documents. Of course, if Whiting were to object to producing those documents in this case, we would have a hearing, Your Honor, as to whether or not that objection should be sustained or overruled. And then with respect to the deposition testimony, that falls under two buckets. One is the Whiting deposition, which we discussed a little bit last week. There are no Whiting depositions other than two small portions that don't apply and we would not intend to use, that Whiting ever designated as confidential or highly confidential. So there's nothing in the protective order that would preclude us from using Whiting deposition. There might be evidentiary issues that we would have to deal with at the time, but there's nothing in the protective order that would preclude us from using it. So then the last bucket is the Shell depositions, which, as I mentioned before, Mr. Durst and I have largely reached an agreement that the parties can use the Shell and Jamex depositions in this case, but there's one caveat or one additional sentence that we would request that they have not agreed to. So I agree with Your Honor in the sense of, from a practical standpoint, what are we fighting about? What Shell has wanted is they want some kind of entry from Your Honor, some kind of ruling from Your Honor that, at least based on their brief on Friday, that they can then point to of, look at what Jamex did, they violated this court order. And what we think is, look, from a practical standpoint, everything has been solved. We've moved forward like Your Honor has suggested and the guidance that the court has entered, and we think that solves the issue.
Your Honor, may I address that briefly?
Your Honor, can I speak when I get a chance? I know Mr. Shigaris is more than capable, my partner, of handling any of this, but I just have a couple of points to make.
We'll let Mr. Durst go and then you can speak.
Thank you, Your Honor.
So, Your Honor, the steps that Ms. Shigaris noted that they have taken, which have been in an attempt to deal with discovery from the Whiting case since the first hearing we had on this issue that the court held, have been the right steps. We are coming to agreement on a protective order. They have sought the discovery from Whiting. Shortly, we'll address the parties' agreement on what to do with depositions. All of those steps, Your Honor, should have been taken before they ran the stop sign of the order. So the issue, Your Honor, should there be a remedy? Should there be consequences for them violating the court order? And Your Honor, candidly, we've had other issues in this dispute with respect to how the lawyers are following rules. And so what ought to happen here, Your Honor, and you know, we're not being punitive, Your Honor. Notice that we haven't asked for sanctions. We haven't even asked for our fees to come back. We understand, Your Honor, the dynamics here in the sense of this is a situation that should have never come into place. It just needs to be resolved and we need to move on. But Your Honor, it was plainly, and nothing that you will hear from Jamex is to the contrary, it was plainly a violation of the court's order. And it put Shell in an unfair advantage, Stesco in an unfair advantage, in the sense that we've got this improperly filed summary judgment motion on the case, on the docket in the case.
Shell was improperly advantaged or disadvantaged?
Disadvantaged. It puts us at a disadvantage by having this improperly filed motion on the docket so early in the case. And Your Honor, if they want to file it again, you know, we're not asking for any substantive ruling on their arguments, but plainly it's akin, Your Honor, to deciding to ask for forgiveness rather than permission. And when it comes to court orders, Your Honor, that simply is not appropriated. So this ought to be dealt with on the docket. And we can,
Ms. Shigaris, why don't you guys, or Mr. whoever wants to answer this, why don't you guys just agree to withdraw this motion? I don't know why we're fighting over this.
Your Honor, I actually had discussed that with Mr. Durst. I said, look, we could agree to that, but that wasn't sufficient because he wants it totally removed from the docket. Obviously, withdrawal means we're not submitting it for consideration at this time. I don't think that accomplished what Mr. Durst wanted, which he wants it completely deleted off the docket, which I continue to say I don't believe that the court has the authority, and I'm not even sure if the clerk has the technology to do that.
So you're representing on the record, if I'm clear about this, that Jamex is withdrawing this summary the offensive summary judgment and will not be pursuing it in the future. Is that correct, Ms. Shigaris?
Well, I want to be really careful with the language. We will not set this specific one that has filed for hearing, but we might file an identical one down the road that has different discovery. I don't want there to be an issue that the summary judgment grounds are somehow waived.
That's not what I'm saying. It's just you're withdrawing this particular, you can always amend a summary judgment or change a summary judgment. You're withdrawing this particular summary judgment. This doesn't prohibit you from filing another summary judgment with identical grounds at some point in the future. Is that what you're doing?
Yes, Your Honor.
Okay. Given that representation, the court is going to deny any additional relief. The motion to seal is granted unless there's some procedural issue with the motion to seal that anybody wants to raise, and any additional relief given the representation of counsel that this motion is withdrawn is going to be denied.
Your Honor, will you, can we request that you put that that it's based upon the representation of Jamex counsel that the motion, or really based upon the withdrawal of the motion, so that we have that rather than having to just have the transcript here. Well, the transcript is fine, but can you enter that either in the docket or on the order that you sign, Your Honor?
Yeah.
Your Honor, hold on. Let me just say this. Mr. Durst is trying to use this in another fashion. I think he's trying to use it in the bankruptcy proceeding in Whiting. I think he's trying to use it here. I'm not sure exactly. So I want to be very careful that we don't look like we're making some kind of merits-based decision or some kind of rules-based decision. Rather than simply withdrawing a motion, we can file the identical motion later. So I want to be very, very clear, because we'll just waste a bunch of time later arguing about coming back to the record and say, Your Honor, you said this, we could refile it. I just don't want to get into that argument later.
Your Honor, a withdrawal without prejudice is fine with me.
Okay, that sounds good. All right, anything else, guys? Did you guys give me an order to sign? I haven't had a chance to open that.
We'll send you one, Your Honor, that comports with this outcome, and I'll run it by the judge.
Go ahead and email my court coordinator, and we'll go from there. All right, guys, we'll go ahead and end this hearing now. Thank you so much.